Good evening, Legal Vidya, and good evening, participants. Am I audible to you all? Okay, just wait for a second. I'm sharing the screen. As you all know, it's the 21st class of the session. We will discuss about some of the more provisions of the CPC in details with the new format too. Just wait sharing the screen. I have shared the PDF, sorry, of the today's session already in the group with the file name, class 21, and so on. If you wish to, then you can open the PDF also. Just wait for a second. I'm sharing the screen. I think the screen might be visible to all. Yes. Today's topic for the session is the order number 12, rule number 6 of the CPC. That is more admission. Today's topic is about the admission. Before directly jumping into the admission, I would like to clear a few points that the admission is first of all, that is the order number 12, rule number 6. It's a very important part when we are discussing about the civil litigation. And when we discuss about the litigation, when we discuss about the trial procedures, then it's also play a very important role in the case of the evidence law also, as I have mentioned in the topic like evidentiary value of the admission. We will discuss this in detail, but first of all, I would like to start that there is a one thing we already heard in the during the litigation. Another term, that is the confession. How many of you are acquainted with the term confession? Actually, there is no as such draft for the admission. It's a part of the litigation. So we are discussing it here. Now, confession. I think many of the students belonging to the law fraternity have heard about it. Look, there is a little bit slight difference between the confession and the admission. Both terms, first of all, are like the synonymous terms, but this is not mentioned somewhere in the law that the confession and the admissions are the same term. When it comes to the confession first, because directly jumping into the topic of admission, it would not be good enough, because you must know about the confession first. So, confession. Anyone have the little bit idea about that? What is the confession under the law? Are the admissions and the confession same? If anyone wish to, then please put in the chat box. But yes, Sony. The confession is just like, okay, okay, when someone admits their crime, it's confession, to plead guilty. Okay, this is what the meaning of the term confession is, Anamika. But when it comes to the procedure of trial under the CPC, then under the confession, you can state that any of the accused just randomly admit or randomly confess that he had pleaded the guilty and so on. So on the behalf of a confession, there is a direct conviction. Okay, the accused has pleaded the guilty, he has confessed something, he has confessed that he has committed the offense or the crime, and then now he might be just convicted. But now when it comes to the admission, first of all, then if the any of the thing is just like that, is being the whole procedure is done through the civil litigation thing, then during the admission, the conviction is not done directly. The conviction is done by the trial procedures that is followed step by step as per mentioned in the code. So this is a very big difference between the both, and you have to be acquainted with it. I think you got the concept. And conviction in the case of admission followed by a particular trial procedure, and conviction in the case of a confession doesn't followed up by any of the trial procedure. It's the direct conviction after the confession. by any of the accused. I hope you got the concept of both confession and the admission in a very crisp way. Yes, now please, we will move forward. Okay, Anamika. Yes, so it's upon the screen. There is no as such draft for the same. Actually, dear participants, now question will be in your mind. It's a drafting certificate course, then why we are not discussing the once again no draft? Because these are the terminologies that play a crucial role during the litigation, so we must be acquainted with these things, with these concepts, because as you already have learnt about the plaint, you have learnt about the ws, so you have learnt about their affidavits also. Now when you have learned about these plain ws and affidavits, then you must be acquainted with that. Okay, what's the role these plaint or the affidavits and the ws playing role, what's their optimum goal is the litigant want to achieve by doing these steps. So this is what the main concept of the same main concept, or we can say just like, okay, for example, infra is there. Okay, infra is just like plain to WS at the affidavits you have filed. But what are the content there in the that, or what are the aspects that are related to them? So these are that only. I hope you got this thing also. I would not read the PDF as it, because it is all available and you can go through it. And these PDFs, what I am sharing about the legal concepts, you can use them for your academics exam preparation also, because in the CPC every time when you write the academics exam, this question is asked, and the students who are preparing for the judiciary also, they have to keep in mind that these type of questions are also asked in the pre of every state's civil just judiciary. The question is asked that what is the preamble of order number 12 rule number 6, and in which section of the evidence act the confession is being mentioned, or where the CPC cannot define at all, and so on. What are the leading case laws of the same? I hope you are getting the thing. Now comes I'm directly jumping into the PDF. If possible, kindly look at the screen. If not, then open the PDF in your mobile, and we will go through this. Now, principle of the admission. Sorry, confession and admission. I have already explained. Now, when we discuss about the admission, then there are two pillars of the justice system. It's a civil justice system as well as the criminal justice system. Everyone is acquainted with this thing. Okay. Now, when it comes about the justice system, the admission under the criminal justice system is more about the confession, where the conviction made directly. But when we comes to the CPSC, Civil Procedure Code, or the civil litigation, then what happened? The confession is not being directly made. It's like a admission, because the suits that are being filed are of the civil in nature. So on that there are certain principles applicable. There are certain courts who are conferred with the certain discretionary powers, and on the behalf of those discretionary powers, on the behalf of incorporated principles, on the behalf of a step followed up for a trial, there are certain decrees that are being made, judgments being passed, and the things that being passed is on only behalf of the admissions that are put forward by the both of the parties via. Now, one of the party would file the admission via a plaint, and the another party of the dispute will file the admission by the way of what? Okay, you tell me, by the way of what? One party is filing the plaint, then the another party is filing what? Yes, anyone? You can unmute yourself also. You are getting what I'm trying to say? Written statement. Yes, obviously. Good, Ranvijay. Yes, yes, written statement. Okay, you got it. And those are supported. Yes, Rahul. Okay, got it, got it. Thank you. Yes, so it means that you are getting my point. Very good. And these are supported by the affidavits. Okay, one thing to keep in mind always, dear participants, is whenever you file any of the document containing any kind of information, then must be accompanied by the affidavit. Always keep in mind, especially in the civil drafting and in the criminal process, criminal litigation also, affidavits are being required. Once the evidence is over, then the court asks you to file the affidavit for the same. Now we will move further. It's already mentioned, order number 12, rule number 6 play a significant role in minimizing litigation, enabling speedy justice. So the article point out there the pivotal role played by the provision in enabling the court to make orders, pass judgment based on the admission. Because when we file the plea, then it's like the court is acquainted with, court comes to know that okay, these are the things happened, these are the things happened like this, the issue between the parties is this, and the parties are seeking this relief on the behalf of these things. So this is the role being played by the plaintiff. And under the WS, it's like okay, the another party have admitted this but denial this, okay, and in the support of that they filed these evidences also. So it's very easy, very convenient for the court to make out the judgment, to just uh, uh, to be just delivering the justice or delivering the decree or just providing the relief to whoever the party is looking for or who are eligible to get the relief, who are seeking the relief. Now comes the another aspect, that is the evidentiary value of the admission. Actually, the thing is, I have it's already mentioned. CPC doesn't define the term admission, is not defined, but section number 17 of the Indian Evidence Act. This is the old law that we are discussing here. So this is also that the section number 17 of the Indian Evidence Act. Okay, now the if the thing is, you will be like, ma'am, why you mentioned the Indian Evidence Act provision? Because the more of the litigation, it's just when you are into the litigation, then there are certain aspects that are being filed before the cases that are being filed before the 1st of July 24. So those would be just those would be governed by the old laws. That's why I mentioned it here. Now it's like section number 7, where the section number 17 is just like a statement made in oral, documentary, or the electronic form. Now the electronic form is the another thing that is being included here, suggesting an interference to the fact in issue or the relevant fact. So a fact in issue or relevant fact. Okay, you tell me. There is a one line being representing on your screen, that is the suggesting an inference to a fact in issue or the relevant fact. Can anyone please tell me what is fact in issue here and what the document we are talking about? Yes, please. Can anyone? Fact in issue is there or the relevant facts are there? We want to quote making acquainted with both the things, fact in issue or relevant fact. Then by which medium we will make the court acquainted with? How you will tell the court, okay, these are the facts, by which way or by which medium? Anyone? No one till now. Okay, you want to tell court about something. How would you approach the court? I am making the question easy. You want to tell something, then how would you tell the court? By application. Okay. But okay, as you have mentioned the application, but can you please tell me there is any such rule, just that you want to tell court something, then you can file the application under which section? Application for what? This is a blunder now you people make when you are studying about the law. That application must be accompanied by any of the legal provisions. Na? By, for example, application for the amendments in the pleading. Yes, obviously, Nagendra, filing a suit. If we want to tell something about the thing, we want to tell something about any, and if there are certain things that are being remaining that are being not mentioned, or we can say by a plaint, not by an application, because application include which under which category you gonna file the application. I ask. Okay, very good, Nagendra. But filing a suit means that if you want to make acquainted court with anything or something, then you can file a suit. You can file a suit is also same as the instituting the suit, or filing the petition in the court, or filing a plaint in the court. Okay. So it's also pertinent that the section number 3 also play a very important role for the same. There is no as such relevancy to read the section number 23 in detail, but you must be just like, okay, the question can be asked, because when any of the student who is pursuing the judiciary, then they have to prepare both the acts. So, because the question can be asked from the old colonial laws also, old Indian Evidence Act also, old CRPC also. Yes, this was the thing I was about to tell you in the previous class also. So please just get acquainted with the index of the old classes or old laws also. Okay. Now there are other sections also that are playing a crucial role. That is the section number 58 also, like the same, that the fact has been admitted by the parties or their agents. Now one term is there, by the agent. Actually, by how we file the plaint in the court. Does we file a plaint by the agent or by ourselves, or on the behalf of someone? I think if you have studied the plaint in detail, you would be able to answer these questions. It's more about just how we file the patent, or who are here. Anyone can tell me who are the agents here? Are there through an advocate? Okay, okay, through an advocate. We file the patent. But who verified the plaint? We ourselves verified the plaint. Na? Then who is the agent here? Agent here. Anyone can tell me who is the agent here? Actually, one term you have heard about is the legal representative. There are three conditions, three circumstances where a legal representative plays a crucial role. Either person is insane, either person is minor. I think you have heard these terms. There are certain legal disabilities there, where we discuss about the LRES. Yeah. That is, the person is insane, person is minor, person is disabled. So in that condition, use the word agent. It means that the section number 58 of the Evidence Act also provided that there are are accompanied by the affidavit, either the parties themselves or the parties above with their agent, means that with their help of their legal representative, then there is no requirement that those facts must be proved. And however, the proviso provides that the court has the discretionary power to require such admitted facts to be proven by means other such as means other than admission. For example, this line saying, so if the court wish to, then court can ask you to file any. These are the um, facts you have mentioned in the plate, or you have mentioned in the WS. But if you wish to, then you have to. So this is what about the law says. So there are certain case laws also for the same. The case law is just the Steel Authority of India. I think you have just studied this case law in the labor law also. In the labor law, it's a Workmen Compensation Act also. It was a case law we discussed. Now there is another thing that I have mentioned upon the PDF, that is talking about the order number 12. Order number 12 particularly deals with the admissions, where there are certain rules. There are certain rules that are being telling about different provisions. So rule number 1 is that the parties can admit the case of the other party entirely, partially, by giving a notice. The notice should be in writing. Very simple thing. No such thing to explain in this. Rule number 2 is also there. Actually, you can have the BREC with yourself, and just you can just go through those provisions, and you must be acquainted with the same. Now the rule number 2 is that the issuance of the notice, that is the party can issue the notice to the other party to admit or to refund, to admit any, refuse to admit any documents. And then what would happen? The opposite party has to admit the documents within the 7 days of service of notice. These 7 days of service of notice can be extended by the court permission. You can mention it there also. If the parties on whom if they refuse or neglect, then the owners of the bearing or the cost of the document will be on the refusing or the neglecting parties. Next is the rule number 3A also is there, that the court to call upon of any party to admit a document to record the admission or the denial. Then the rule number 4 is there. Admissions made by the virtue of notice under a particular proceeding can't be used against the party. So these are certain aspects that are dealing with the admission in the civil litigation particularly. Now comes the another part, that is the order number 12, rule number 6. Now, order number 12, rule number 6 is means that the court is making any of the judgment. And okay, the judgment is can someone okay, someone wants to join the call. Wait, someone is there looking. Yes, actually, the people were waiting. Yes, can you please tell me that the judgment, what is judgment under the CPC? I think you have gone through the definition section of the CPC. Under which section? Okay, tell me under which section of the definition clause? Devendra Nagendra, guardian, ma'am. Yes, the guardian can also be the legal representative. They could be. In the case of a minor, the guardian can be the legal representative. Section number 9, section number section number 2, subsection number 9, 29. Okay. Yes, you people are studying. Good going. Good going, Anamika. Good going, Ranvijay. Okay. Now, up on the screen, you are seeing that I have mentioned the order number 12, rule number 6. Then what happened? Under this section, the court the court is empowered that they can make any of the judgment and regarding any of the oral or the written statement that have been made by the parties, and the admission that is being made by the parties under the pleading. Here, what is used the pleading? Pleading means either the WS, either the plaint. So if there is something you have written there in the CPC, the pleading word you have written there, then you must be just like okay, or the supporting documents filed with it. Now there are certain case laws with the same. You can study the case laws by yourself. But there is a thing that in the last paragraph, we will jump directly into the last paragraph where I have mentioned that the court may pass a judgment. May pass a judgment means that it's only the discretionary power of the court that they can pass on the judgment, that is that the facts that are being mentioned under the pleadings. Then there is no as such a further thing that the court can pass the judgment other than that. Whatever there in the pleadings, the court can pass the judgment to that part only. Just take a 1 second and just read this paragraph what I have mentioned, and then I will share the next part of the class. If you got the concept, then please give us a thumbs up. Okay, Anamika. Actually, every law student is just like CPC is very horrible. It is very tough. CPC is not tough at all. It is lengthy. It is interconnected. Once you have just done with the vocab of the CPC, then you are just like, or once you have acquainted with, okay, these are the steps involved in the civil litigation, or these are the meaning of these things, then the CPC is the best to learn by. And students score full marks, and can do all the MCQs that are being asked under the CPC in the civil judiciary exam. Anyone is preparing for the judiciary here else? Gives a thumbs up. Meanwhile, I'm sharing another PDF. Okay, Ranjini. Yes, prepare hard. I'm just sharing another screen for the class. Wait for a second. Now, another part of the class is about the summary suit, how they are being filed, how they are being instituted. Just wait. If anyone have any query regarding the same, then please, you can please. Screen visible to you all? Okay, Ranvij. Okay, sorry. Okay, Shrishti. Okay, okay, Sanket. Okay, got it, got it. Now, another part of the today's class is about the how what is the process that the summary suit are being instituted. Just wait for a second. It's a power cut here. Just be in the class, students. Yes. And now the summary suit. This is also a kind of a plaint, means that we are presenting a plaint in the court, and the plaint that are containing specific things, that are containing special facts, or that are containing special mentionings, then that is being defined under the summary suit. There is a way for filing the summary suit. And okay, one question will be there in your mind, ma'am: what is the utility of filing the summary suit, or why there is a need to? So summary suit is just like the reliefs that are being you are seeking on a very particular basis. That and the summary suit are somehow is also like that the all the allegations that are being put forward in the plaint are that are being directly admitted by the another party. So this is what the summary suit is. Okay, and there is no as such. Now one question is also there in your mind, that there is no as such draft. We have discussed the draft of the plaint. How many have you acquainted with the draft of the plaint? I think everyone might be acquainted with draft of the plaint. So that is the draft of the plaint is only the thing that is being used here. Okay, Shrishti. Okay, everyone. Yes, the draft of the plaint is the same thing that is being used for the same drafting. So that's why. And these are the important aspects that I. That's why the legal vidya have involved these concepts in the during the class. Now, summary suit is being. I will go through the PDF only. It's instituted by presenting a plaint. Simple thing is that it is a presentation of plaint, and certain specifications are there. And for example, when you file any kind of a suit or a plaint in the court, then it should be mentioned that okay, the suit is under this order, or under this thing. Or for example, suit is under order number 37 of the CPC. If there is any suit mentioned above that, that is under order number 37, that will, you must be just like okay, it's a summary suit. And there is that no relief which doesn't fall within the ambit of the rule has been claimed. And this is a very important thing, or a declaration that is being made, that the summons are also issued for the same. Summons are issued for the appearance of the appearance to the defendant. What's the purpose? You can be just in your mind have the question. So that is as per the form number 4, form number 4, that is accompanied by the copy of plaint and annexures. A plaint means simple the plaint that is being filed in the court, and annexes what are the other annexes that is being filed along with the plaint. For example, any of the supporting evidences for the plaint statements, or any of the affidavits there, or any other thing that is being required as per the court law. That is okay. Now, when the defendant just received the summons, then he have to be appear in the court within the 10 days, and that the days will be excluding the holidays and so on. On the default of the appearance, that and the default of the appearance means that the defendant doesn't appear, or then that it means that there are certain allegations that are being made in the plaint that are being just accepted, and the all the that is being mentioned in the reliefs, that is without any argument, without any further proceeding, will be provided to the plaintiff. And then what would happen if the enter if the, when the defendant is there just like entering upon the appearance, then the plaintiff have to file the to just required to reserve him on the summons for the judgment. And for the judgment, then that is also being accompanied by all the affidavits, all the other cause of action aspects, and so on. And now it's also just like the defendant can also apply for the leave to defend the suit within the 10 days from the date of the services. So these are the further reliefs the defendant can take. And then in that condition, the court also cannot deny any of the defendant that he cannot defend the suit until he believes that the disclosure by the defendant doesn't show any of the substantial kind of defense that is raised to be frivolous. So these are the certain aspects that the summary suit being being instituted, being filed, and they are being disposed on the appearance and the non-appearance. Madam, I am not able to understand what is the summary suit and when it is exactly issued. Look, there are certain kinds of a suit file, certain kinds of a plaint filed in the court. Okay, so one of them is categorized as the summary suit, where the summary suit is just like you have filed a suit and you are just acquainted with the fact that the okay, the defendant will not be there just to defend, or that their defendant will not be there to just settle the claims and so on. Then you file the suit under the order number 37 of the CPC. Then what would happen? It's a kind of a providing the speedy justice for the same. Then what would happen if the summons are being issued? Then after the summons being issued, if within the 10 to 15 days, if the defendant doesn't appear in the court, then what would happen? The judgment will be delivered upon what are the facts, what are the allegations, and what are the relief seeked from the release, speedy trial, okay, speedy delivery of the justice. It's, you can just be understand like, okay, it's like a speedy trial, but it's a speedy delivery of the justice. Okay, then what happened? The court issued the judgment. Yes, and then if the defendant appears, then what would happen? If the defendant appears and he is just taking the relief from the court, then court cannot deny the relief. Then court will give the time period, and if the court assume that the facts that he is taking the help with are not frivolous at all. Madhukar, is there any format for the leave to defend and the suit? There is no as such format for the leave to defend and the suit, defend the suit, but it's just like a simple application. You have to be just mention and so is it to get an ex parte order or the decree? You should know as such, no as such. Sony, no as such. But yes, in the practical, okay, listen, Sony, there are two aspects. That one is being that is being practiced in the court of law, and one is being that we are studying in the books in the Bear Act. So as per the Bear Act, there is no as such provision to get an ex parte order or a decree issued, because ex parte order is something where the defendant doesn't appear in the court after resummoning, issuing of the summons again and again. So it can be similar to the ex parte order, but it is not an getting an ex parte order. Yes. Anyone else have any query? Please do ask. But if you want to tell your client about the same, that you can use these terms that okay, we want to get the ex parte order, because what we understand as a lawyer, as an advocate, we can't make acquainted with the client, because client is not prepared to discuss these technical things, na. So you can use these things to just discuss with the client, but not to examples where the summary suit. Please share the examples where the summary suits can be filed. The Madhukar, there is no such limit that in that case the summary suit can be filed or not, but the summary suit can particularly filed in the cases of a contract, especially the summary suits are being filed, because the in the contracts only, and for the matrimonial disputes, no such summary suits are being filed. Loan cases, please can you elaborate that what is the loan case you are talking about? Because in the loan cases there can be the fraud or the forgery also, na. So if you are talking about the recovery of the money, then yes, you can say that okay, we can file the summary suit. Yes, for the recovery of the money, absolutely. So that is not defined as a loan case, because in the loan case there can be the check bounce case also. There can be the fraud and the forgery also. Actually, the summary suit, now you can also say is that it's a kind of the court is adopting a very particular, very accomplished, very small thing procedure, just to decide the case, and just to the court is granting the decree. And the important thing is that regarding the summary suit, I didn't remember about the value of the suit, but there are certain values that within which ambit you can file the summary suit with the court having the pecuniary jurisdiction. Because we all know that the civil courts are also empowered, or the high courts are also empowered. Or in the loan case, you can also discuss about, for example, promissory note cases or the hundi cases are there. So these are the cases. Or for example, liquidated insurance claim case. Insurance claim case, if there is no such fraud or the forgery is there, then you can file the summary suit. But I think insurance case are more dealt with the IRDA. So not sure about the same. But for the money recovery, yes, you can. It's just like there are certain parameters na, that the suit is being declared. Can summary suit be filed in 138 cases? Negotiable instrument at 138 cases? No, not actually, because under the section number 138, criminal liability is there. And if the court wish to, then only, na, but no, not as such. And most important thing, for filing the summary suit, there is a limitation that within the 3 years of the cause of action you can file the summary suit. So, for example, Madhukar, I think you are dealing with the section number 138 negotiable instrument act only. If you have any doubt regarding that, if you are having any matter you are involved in, then please mention me or ping me on the WhatsApp. We'll try to help you out for the same. Because earlier also, I think you have discussed about the same 138 and negotiable instrument act 138 case only. Would definitely like to help you, Madhukar. If anyhow I can, ping me on the WhatsApp. The summary suit are being filed where there is a civil liability particularly. Yes, anyone else have any question? If you understand the concept, please go through the PDF once again after the session is over. And if any doubt, then please clear in the second year. Okay, we have come to the class number 21 or 20 something. Did you have any of the doubt in the previous classes? We'll try to resolve as much as queries in the revision sessions also. But I think on the regular basis also the queries must be resolved. I think no one have any queries. If yes, please ask. Else I would request the legal Vidya to wrap the session. Okay, thank you, participants present over here. Legal, thank you, Akash. Legal Vidya trying to say something, you are not audible. Please. Yes, thank you, Ranvijay. And thank you, everyone present over here. Yes, legal Vidya, you are not audible. Okay, thank you, Jashri. Stay safe, stay healthy. अपनी health का ध्यान रखिए और happy learning.
And thank you so much, ma'am, for such a wonderful session. Now, I would request to leave the session, everyone. Thank you so much.
Thanks, legal Vidya, and thanks, participants. Good night, happy learning.